Okay, good evening. This is Thomas Freed on the Liberty Works Radio Network. This is the Truth Attack Hour, and yes, that's right. We're back. We're back with the Truth Attack. So, I hope everyone has had a good Christmas vacation. We, of course, were off last week for that, and we're back this week with lots of new information about what's going on with the fraudulent application of the income tax by the federal government, which has been exposed by the Supreme Court in a decision they issued last June. Been exposed as a complete and total fraud, and we'll get into that in just a minute. So, we are the Liberty Works Radio Network, and we do need the support of the members of the listening audience to keep the network operating and the broadcast coming. So if you enjoy the information, the discussion, the lectures, the guests on the other shows, and generally the nature of the broadcasts, which is anti-progressive and one of the true conservative voices in the country, we sure would appreciate it if you could find your way over to the LibertyWorksRadioNetwork.com website, if you're not there listening online already, and get signed up as a subscribing member, even if it's as little as $20 a month. Every membership helps, and we do need the support of the listening audience to keep the show coming. And if you want to get fully informed on the fraudulent nature of the income tax and how the American people have been deceived by the IRS, the DOJ, and in fact, the lower federal courts, both district and circuit courts of appeals, for the last 75 or 80 years, depending upon whether you want to start counting from 1950 or 1945. It's all there at tax-freedom.com, taxfreedom.com. It's in book form at irszoom.com for just $6. And the articles at Tax Freedom expose the broken tax system since the new Trump tax law was put in place. It's been exposed. And the SCOTUS, the Supreme Court decision in June, finishes the expose, finishes the uncovering of the fraud that's been perpetrated on the American people. All of this is available at taxfreedom.com. You can get help answering the IRS at irszoom.com. You can pick up the information in just a $6 booklet form at irszoom.com, or you can get the comprehensive compendium of 30 years of work establishing the truth about the income tax. And after the Supreme Court decision in June, I don't have to change a word in any of it. It's 800 pages of educational material that will set you straight. It's just $50 at irszoom.com if you like the comprehensive material. That's the way to go. If you want the introductory reader, that's just $6, The Simple Truth About Income Tax. Okay, so let's get into this. As I've been telling you for the last couple of months, the Supreme Court issued a decision last June which terminates the IRS's and the federal courts and the tax court and the Department of Justice's fraudulent enforcement of the income tax. They're finished. What am I talking about? Well, I'm talking about the fact that for the last 50 years, the IRS and the DOJ have had published on the internet a frivolous argument positions document that alleges, basically, the decision of the Supreme Court last June is frivolous. Why? Because the IRS has been assessing the tax on the basis of an allegation that the 16th Amendment authorized, allegedly, a direct tax on income without limitation. And being authorized to tax directly and without limitation, they have used Section 61 sources, rent, interest, dividend, compensation, commissions, annuities, etc., including salaries and wages, even though they're not in the section. They've used Section 61 and its sources as the basis to tax Americans directly on all of those sources without limitation. No uniformity and no apportionment of the tax, because they argue the 16th Amendment authorizes a direct tax under the 16th Amendment. Now that's wrong, because the word direct isn't in the amendment, And you would need the word direct in order to create a power to tax directly. There's no enabling enforcement clause in the amendment, so it doesn't matter whether you allege it created a new power to tax directly or a new power to tax indirectly. Congress isn't authorized to write law to enforce that newly alleged power. And that's because none is created. The Supreme Court said no new powers, no new subjects. Income isn't a new power. The 16th Amendment and its power to tax income do not constitute a direct tax without limitation. And it constitutes an indirect tax. And income isn't a new power to tax indirectly either, because again, that would be a new power. Previously, the only powers to tax indirectly were impost, duty, and excise. To tax income indirectly would be a new power. Without an enabling enforcement clause in the amendment, Congress couldn't write law to enforce that new power. So these are the reasons why the Supreme Court said in 1916 in Bruce-Shaber, the original decision, that no new powers are created, no new subjects are created. And no new law is authorized to be written. So you can ask, well then, what does the 16th Amendment do? What it does, what it did, is it prohibits the federal judges from doing, again, what they did in 1896. They can no longer use a source argument as the basis for a finding that the tax legislation being tested in the case before them is unconstitutionally direct, because it's direct because of the source, and as a direct tax, it's not apportioned to the state, so it can't be sustained. And that's exactly what they ruled in Pollock v. Farmers Loan and Trust in 1896, that a tax on income, rents, was direct because of the source tax. Rent streams from property, that's a tax on the property. Taxes on property are direct taxes. So it was deemed to be a direct tax because of the source tax, rent streaming from property. Tax on property is a direct tax. Now, this was all nonsense because property doesn't pay the rent. A third-party tenant pays the rent for leasing the land to grow crops on it. And that's straight up the alley of excise taxation of the commodity, the use of the commodity land, and its consumption, which is depleted of value when you grow crops on it and don't roll fertilizer back into it every other year at least. So, and also, of course, rent could be taxed as earned by a corporate person enjoying the privilege of earning money as a corporate person, enjoying the privilege of incorporation, and therefore everything they earn can be taxed regardless of the source. So Pollock was all nonsense. And it created all these problems because the liberal progressive Fabians of that era spent the next 20 years writing the 16th Amendment, which has now been used for 100 years to bamboozle, lie, and rob the American people under the pretense that the 16th Amendment changed everything. Well, the Supreme Court said no, it didn't change everything. It changed nothing. Income isn't the object of the tax. It isn't the subject of taxation. The way it's being used today is both object and subject. Income is the yardstick. It's the mechanism by which the amount of tax owed is measured. The amount of tax owed is based on how much profit you had on the earnings derived from the activity or transaction subject to federal taxation by impost, duty, and excise. Impost taxes foreign persons, foreign activity, foreign imports, and in foreign places, like foreign countries under tax treaties or in territories and possessions. Impost is foreign taxation. It doesn't apply to the labor of the American people in the 50 states. Duties are the taxation of exported goods leaving the country for sale, resale, or consumption in foreign markets, and we have no duties. We have duty-free shops at the airport. If you're leaving the country, you can buy as many American goods as you want, completely free of all taxes. And you can take them to other countries to resell or consume. And duties, of course, obviously, do not touch the labor of the American people with legal effect as tax. So imposts don't tax American labor. Duties don't tax American labor. Excise, in 1911, the Supreme Court ruled that excise taxes are taxes on the manufacture, consumption, and sale of commodities within the country, things like alcohol, tobacco, firearms, petroleum fuels. It's a power to tax licenses to pursue certain occupations, like a license to sell alcohol, tobacco, or firearms, and it's a tax on the corporate privilege, where it is the privilege of the license or of incorporation that is the subject of the tax, and income again measures the amount of tax owed from the earnings derived from the privilege, the license or the incorporation. And again, excise doesn't tax the labor of the American people. Now, the labor unions actually saw this coming in the 1930s when they passed Social Security. The labor unions got alarmed and said, oh my God, they're going to try and tax the labor of the American people. They're doing it with Social Security. This is voluntary, but I can see where it's not going to be. So they went to Congress and they made them pass Title 15, Section 17, which says the labor of a human being is not a commodity or article of commerce. And by that statute, your labor cannot be argued to be a commodity subject to excise taxation. So labor of the American people within the 50 states conducted by right rather than license or privilege is not a federally taxable activity or transaction to the federal government. You can't tax labor based on impost, duty, or excise. No new powers are created. It's not a new power to tax indirectly income. It's not a new power to tax directly. And that's why they've had to lie about the 16th Amendment and claim it is a new power to tax directly under the amendment, because there's no other way to get through the Constitution with a taxing power that touches the labor of the American people conducted within the 50 states by right rather than privilege or license. You can't tax labor by impost, duty, or excise. It's foreign, import, export, commodities, licenses, corporations. There is no taxation of rent. There is no taxation of interest. There is no taxation of dividends, regardless of the source. Sources aren't a valid basis for indirect taxation by impost, duty, and excise under Article 1, Section 8. Sources of income under Section 61 are only an arguable basis for the owing of tax if you can deceive the people into believing it's a direct, non-apportioned tax under the 16th Amendment, without limitation and without need of any applicable impost, duty, or excise, which is the only basis for taxation under Article 1. Foreign, import, export, license, commodity, and privilege. That's it. There's no taxation of labor. Article 1, Section 8 doesn't allow for the taxation of the labor of the American people. That's why they've had to lie since 1955 and claim that it's the 16th Amendment that creates a new power for them to tax and own you. If they raise the tax to 100%, they'll own you. You'll work all day and go home with nothing. And that's how you test whether something is reasonable or not. You test the theoretical extreme and see what happens in the extreme application of the theory. So there is no authority to tax labor under Article 1, Section 8, Clause 1 that was deemed inconceivable by the Founding Fathers. If every time a man works, he owes money to someone as a result of making money as a function of the work, that man's not free. He is owned. That's the definition of a peon and a slave, an indentured servant almost. That's not freedom. It was inconceivable to the Founding Fathers that the federal government would ever be taxing the labors of every single person in the country across all 50 states. Inconceivable! Any such tax would be direct and must be apportioned to the states. That's why it hasn't been laid. We hear the first commercial break coming up. This is Thomas Freed on the Liberty Works Radio Network. Get tuned in, get signed up. We'll be back in 5. Okay, excuse me, this is Thomas Fried on the Liberty Works Radio Network. Freedom comes from God, not the government. God is the truth, and truth shall set you free. So get on over to taxfreedom.com, start reading, learn the truth about the income tax, and set yourself free. Everyone in the country should claim exempt under W-4 and stop filing, and that's pretty much the end of it. Okay, so here we are. The IRS, the DOJ, and the lower federal courts since the 1960s and in precedent since the 1980s have been enforcing the federal income tax as a direct, non-apportioned, unlimited tax under authority of the 16th Amendment. And based on that direct tax, they've been claiming you owe it because you have sources of earnings under Section 61. Compensation for services, fees, commissions, fringe benefits, gains derived from business, gains derived from property, interest, rents, royalties, dividends, annuities, life insurance, indebtedness discharge, all of these things. Now, what would be the basis for taxing any of those sources indirectly by impost, duty, or excise? The only basis would be in the territories or possessions or in a foreign country under tax treaty. None of these sources are taxable by impost, duty, excise unless they're earned by the corporate person, the licensed person, the privileged foreign person, or someone in the territories or possessions or operating as a citizen of America in a foreign country under a tax treaty. That's the only way any of these sources could reach you as an indirect application of the taxing powers. It can't be done through Article 1, Section 8. It can't be done as impost, duty, or excise. They don't tax labor. That's why the government has been lying to you for 75 years since World War II, telling you your labor is subject to a direct tax under the 16th Amendment. And all the lower courts have been engaged in an insurrection against the Constitution, the limited government, the Supreme Court's holdings, which said it's not a direct tax. It's not a new power to tax, neither directly nor indirectly. It's the same thing it always was, before Pollock. It's the mechanism by which the amount of an impost, duty, or excise is measured. Making money isn't the basis for federal tax. That's direct taxation and enslavement, depending upon whether they want 5% or 100%. But that's enslavement, a form of enslavement. It was inconceivable to the founding fathers that the federal government would ever try to tax the labors of the American people. Any direct tax on such labor would have to be apportioned to the government, be impossible to the states, would be impossible for the states to pay. It could never do it. They don't have access to that kind of capital. They can barely raise the money to pay a tax on like $10 a head, $100 a head. They have to let a bond to raise that money. Imagine if they had to pay $10,000 for a man that made 50. Yeah, right, check, that's going to happen, right? Without the state being on your door, stealing everything you have. Okay, so what did the Supreme Court say? Because the Department of Justice is responding to these people I'm helping in court saying, oh, the more doesn't mean anything. It doesn't affect anything. That's about foreign taxation. So let's read what the Supreme Court said. And this is at the beginning. We must decide whether the 2017 Mandatory Repatriation Tax, or MRT, exceeds Congress's constitutional authority. To analyze that question, we begin with a brief review of Congress's taxing power under the Constitution. Okay, so the court says they're reviewing the taxing powers of Congress under the Constitution. Now, there's a couple of paragraphs about before the Constitution with trouble and revenue and so forth, and it gets to here, which are irrelevant. What happened before 1788 are pretty much irrelevant. So here we get to Article 1 of the Constitution affords Congress broad power to lay and collect taxes, duties, imposts, and excises. Article 1, Section 8. That power includes two great classes of taxes, direct taxes and indirect taxes. And they cite Brushaver v. Union Pacific Railroad Company. So they're citing the original decision as the basis for this. and pointing out the Constitution says there's two powers, direct and indirect. Generally speaking, they go on. Generally speaking, direct taxes are those taxes imposed on persons or property. See National Federation of Independent Business v. Sebelius. That's the Obama healthcare decision, where they said the direct tax can't be there. As a practical matter, however, Congress has rarely enacted direct taxes because the Constitution requires that direct taxes be apportioned among the states. Still requires it. To be apportioned, direct taxes must be imposed in proportion to the census of enumeration. U.S. Constitution, Article 1, Section 9, Clause 4. See also Section 2, Clause 3. Those are the sections I've been teaching for 30 years. Limit the power to tax directly. They've never been repealed, never been amended. 1, 2, 3 says representatives and direct taxes shall be apportioned amongst the several states. And 194 says no capitation or other direct tax shall be laid unless in proportion to the census hereinbefore required to be taken. These limitations on the power to tax directly have never been altered or repealed, not even by the 16th Amendment. And right here, the Supreme Court tells us they're still in place. They go on. So if Congress imposed a property tax on every American homeowner, the citizens of a state with 5% of the population would pay 5% of the total property tax, even if the value of their combined property added up to only 3% of the total value of homes in the United States. To pay 5%, the tax rate on the citizens of that state would need to be substantially higher than the tax rate in a neighboring state with the same population, but more valuable homes. To state the obvious, that kind of complicated and politically unpalatable result has made direct taxes difficult to enact. Indeed, the parties have cited no apportioned direct taxes in the current Internal Revenue Code, and it appears that Congress has not enacted an apportioned tax since the Civil War. No direct taxes, they don't exist. By contrast, indirect taxes are the familiar federal taxes imposed on activities or transactions. That category of taxes includes duties, imposts, and excise taxes, as well as income taxes. U.S. Constitution, Article 1, Section 8, Clause 1, Amendment 16. Here the court's telling you the 16th Amendment is part of making the income tax indirect. It's not direct like the IRS and the DOJ and the lower courts have been enforcing it fraudulently, unconstitutionally for 75 years. It's indirect under the 16th Amendment. The Supreme Court specifically makes a point about that. Under the Constitution, indirect taxes must be uniform throughout the United States. Article 1, Section 8, Clause 1. Again, citing 181. A tax is uniform when it operates with the same force and effect in every place where the subject of it is found. Geographical uniformity. It's United States v. Tasinski. The court goes on. Because income taxes are indirect taxes, they are permitted under Article 1, Section 8 without apportionment. So you see, the 16th Amendment doesn't create a direct tax without apportionment. It permanently classifies the income tax as an indirect tax without apportionment, because indirect taxes don't need to be apportioned. They only need to be uniform. But the apportionment requirement still exists. There's no such thing as a non-apportioned direct tax. There's no such thing as the tax the government has been enforcing on you for 60 years. It doesn't exist in the Constitution. It never existed. The whole thing has been a huge, monumental fraud. Socialist, communistic sedition from the federal judges in the circuit courts. They've all got their own little opinion that says it's a non-apportioned direct tax under the 16th Amendment, and anyone who argues differently is making a frivolous argument. Well, maybe those goddamn judges should go tell the Supreme Court their decision is frivolous. Let's keep going. Article 1, Section 8's grant of taxing power is exhaustive, meaning that it could never reasonably be questioned from the founding that it included the power to lay and collect income taxes. Bruce-Shaber, 240 U.S. 1. From the beginning, they could collect income taxes based on the privilege, incorporation, license, or foreign, not based on the labor of the citizen. And they had income taxes in the 1880s on the corporate person, the licensed person, but never the labor of a citizen, because impost, duty, and excise don't reach the labor of a citizen. You might have been able to argue that before 1935, but you can't now after this law. Title 15, Section 17 says labor of a human being is not a commodity, which would be subject to excise taxation. In 1861, Congress enacted the nation's first unapportioned income tax, 12 Stat 309. The Civil War income tax was recognized as an indirect tax under the head of excises, duties, and imposts, again citing Bruce-Shaber and Springer v. United States. They then talk about how Pollock created the confusion about sources leading to the 16th Amendment, and they conclude with this. Therefore, the 16th Amendment expressly confirmed what had been the understanding of the Constitution before Pollock. Taxes on income, including taxes on income from property, are indirect taxes that need not be apportioned, again citing Bruce-Shaber. Meanwhile, property taxes remain direct taxes that must be apportioned. See Helverine v. Independent Life Insurance. Okay, so the Supreme Court does a constitutional review, a comprehensive review of all the taxing powers. They say income taxes are indirect. Direct taxes are apportioned and laid in proportion to the census. And the government, who argues that it's a non-apportioned direct tax under the 16th Amendment, says Moore doesn't affect the income tax. You're kidding me, right? You're blatantly violating every single tenet in the Constitution and in the Supreme Court. You're using the 16th Amendment to create and enforce a new power the court says doesn't exist. It never did exist. Direct taxes still are subject to the limitations. They weren't removed. Nothing was repealed or amended. No new powers were created. No new subjects were brought under the umbrella of federal taxing power. Citizens were outside that umbrella before the 16th Amendment, and it creates no new powers and no new subjects. You're still outside the umbrella. And your rent isn't subject to federal taxation. Your dividends aren't subject to federal taxation. Your interest is not subject to federal taxation. None of it is earned in a foreign place, subject to an impost. None of it is earned in a foreign country, subject to the tax treaty. None of it is earned under a corporate privilege. None of it is earned as a result of a license held. It's all non-taxable, exempt, constitutionally exempt sources from indirect taxation. As I've said before, Section 61 is completely misapplied today. It originated not in 1913, but in 1918, 5 years after the original legislation. And the original legislation, Section 61, was enacted under was a Canadian tax treaty that expired in 1993. And when it expired, so too did all of the statutes enacted under the treaty. It's been dead letter law for over 30 years. It never had application to domestic income. That all came out of, guess where it came from. That's right, judicial legislation. The crime of some judge making up the law. We'll be back in 5. I hear the commercial break coming up. This is Thomas Freed on the Liberty Works Radio Network. Get signed up. We need your support. I'll keep talking. I'll keep teaching. We'll be back to look at that right to work in 5 minutes. Okay, this is Thomas Fried on the Liberty Works Radio Network. This is the Truth Attack Hour, and we're back to finish up tonight's show. Okay, so I just got through reading the excerpt from the Moore decision where they do a comprehensive review of the constitutional authorities, and they say income taxes are indirect taxes. They're not a direct tax under the 16th Amendment. Every single one of the circuit court's precedents that they invoke today to fine people up to what, $25,000 for arguing it's not a direct tax under the 16th Amendment, it's an indirect tax and you're misapplying it. And that was the correct argument. That was the correct argument. And the Supreme Court let it go for 50 years. But this court, Trump's court, has reined it in. They've repeated Bruce Shaber, invoking Bruce Shaber, which means there's never been anything different other than the insurrectionist, seditionist rebellion being perpetrated by the seditionist circuit court judges betraying America with this treason. Literal treason to enslave the American people to the government rather than limit the government to the role of the representative. And who do you think the government represents? Does it represent China? Or the EU? Or Mexico? Does it represent the illegal aliens? Who is the government supposed to represent? Isn't that we, the people? So if they're our representative and are only allowed to exercise as such representative the limited powers granted to it by the Constitution, where do all the other powers reside not granted? That's right, they reside with we the people or the state governments, who also represent the people of the state. And it's the people who are at the top of the pyramid as the true sovereign, the first nation of kings, we the people. We are the sovereign power, not the federal government. The federal government is our representative. And the representative doesn't own or tax the sovereign. It taxes the government's subjects under the limited powers they're authorized: impost, duty, and excise, license, corporate and foreign, import, export, and in foreign places, the territories, the possessions, and under treaties. This is all shown in the published law. It's all there in the American Tax Bible, just $50 at irszoom.com. All this information about Moore and the broken tax system and the fact that in 2018, just 6 years ago, Congress invoked Article 1, Section 8, Clause 1 as the constitutional authority for the new income tax law that Donald Trump signed in January. How the government, the IRS, the DOJ, and the federal courts have been getting away with lying about it being a non-apportioned direct tax under the 16th Amendment, since the authority in the constitutional authority statement published on the congressional record says Article 1, Section 8, Clause 1. Every single published fact says the government is lying to you about this. Lying to you for 100 years. Well, 80, since the end of World War II. There is no authority to tax the labor of the American people. The whole thing is a fraud. The labor of the American people is not taxed under Article 1, Section 8, Clause 1. They've admitted it. They know it. And that's why they've had to lie to you and tell you it's the 16th Amendment. Because 181 don't get you there. And now the Supreme Court says 181 is all there is. Direct taxes aren't paid by the people and can't be enforced against them. It can only be enforced against the state that it must be apportioned to as a direct tax. Oh, but it's not apportioned. That means it's direct tax without apportionment, the IRS. No, that means it's an indirect tax and no one has to pay it on their labor, because impost, duty, and excise doesn't tax the labors of the American people. What has the Supreme Court said about this matter? It requires no argument to show that the right to work for a living in the common occupations of the community is of the very essence of the personal freedom and opportunity that it was the purpose of the 14th Amendment to secure. Butchers Union Company versus Crescent City, citing Barbier, Connolly, Yick Woe versus Hopkins, Algier versus Louisiana, Coppage v. Kansas, Truax v. Raich, and repeated again in R.E. Griffiths in 1973. I think that Butchers Union goes back to the 1880s, I'm not sure. Requires no argument to show that the right to work, the right to follow any lawful vocation and to make contracts, is as completely within the protection of the Constitution as the right to hold property free from unwarranted seizure, or the liberty to go when and where one will. One of the ways of obtaining property is by contract. The right, therefore, to contract cannot be infringed by the legislature without violating the letter and spirit of the Constitution. Every citizen is protected in his right to work, where and for whom he will. He may select not only his employer, but also his associates. Coppage v. Kansas, 1915, citing Coffeyville Brick Company v. Perry. And there's another one. Insofar as a man is deprived of the right to labor, his liberty is restricted, his capacity to earn wages and acquire property is lessened, and he is denied the protection which the law affords those who are permitted to work. Liberty means more than freedom from servitude, and the constitutional guarantee is an assurance that the citizen shall be protected in the right to use his powers of mind and body in any lawful calling. Massachusetts Board of Retirement v. Mercia, 1976. It goes on, whether fundamental or not, the right of the individual to engage in any of the common occupations of life has been repeatedly recognized by this court as falling within the concept of liberty guaranteed by the 14th Amendment. Board of Regents v. Roth, quoting Meyer v. Nebraska. As long ago as Butchers Union Company v. Crescent City, which I quoted earlier, Mr. Justice Bradley wrote that this right is an inalienable right. It was formulated as such under the phrase pursuit of happiness in the Declaration of Independence. The right is a large ingredient in the civil liberty of the citizen. It at 762, concurring opinion, and in Smith v. Texas, and invalidating a law that criminally penalized anyone who served as a freight train conductor without having previously served as a brakeman, and that thereby excluded numerous equally qualified employees from that position. The court recognized that all men are entitled to the equal protection of the law in their right to work for the support of themselves and families. In Meyer v. Nebraska, the court held, while this court has not attempted to define with exactness the liberty thus guaranteed, the term has received much consideration, and some of the included things have been definitely stated. Without doubt, it denotes not merely freedom from bodily restraint, but also the right of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, establish a home, and bring up children, to worship God according to the dictates of his own conscience, and generally to enjoy those privileges long recognized at common law as essential to the orderly pursuit of happiness by free men. The list of sites connected to this is just slaughterhouse cases, Butchers Union, Yick Woe v. Hopkins, Minnesota Barber, Algier, Louisiana. It goes on and on and on. Okay. I think there's a couple more here. Hold on, let's see what we got. Oh, well, here's what the Supreme Court said about the nature of indirect taxes. Duties and imposts are terms commonly applied to levies made by governments on the importation or exportation of commodities. Excises are taxes laid upon the manufacture, sale, or consumption of commodities within the country, upon licenses to pursue certain occupations, and upon corporate privileges. The requirement to pay such taxes involves the exercise of the privilege or engagement in the specific activity or transaction, as the Supreme Court laid it out. And if business is not done in the manner described, no tax is payable. It is the privilege which is the subject of the tax, and not the mere buying, selling, or handling of goods, or having of profit. It's the privilege that is the subject. It's the profit that is the yardstick that measures the tax. It's not the subject. It's not the object. And just because you make money doesn't mean you owe the government tax because of a source of alleged income. I'd go another step and argue there is no profit in an hour of labor. What they say about income? Evidently, Congress adopted the income as the measure of the tax to be imposed with respect to the doing of business in corporate form, because it desired that the excise should be imposed, approximately at least, with regard to the amount of benefit presumably derived by such corporations from the current operations of the government. In Flint v. Stone Tracy, 220 U.S. 107, it was held that Congress, in exercising the right to tax a legitimate subject of taxation as a franchise or privilege, was not debarred by the Constitution from measuring the taxation by the total income, although derived in part from property which, considered by itself, was not taxable. It was reasonable that Congress should fix upon gross income without distinction as to source as a convenient and sufficiently accurate index of the importance of the business transacted. Stratton's Independence Limited v. Halbert from 1913. So this is before the income tax hit things, but they're upholding the corporate income tax based on the power to tax the corporate privilege. And the profit becomes the yardstick that measures how much tax is owed. Of course, it isn't, because they artificially inflate expenses to escape the tax. But hey, that's a whole nother discussion. Well, let's keep going. This court had decided in the Pollock case that the income tax law of 1894 amounted in effect to direct tax upon property and was invalid because not apportioned according to population as prescribed by the Constitution. The Act of 1909 avoided this difficulty by imposing not an income tax, but an excise tax upon the conduct of business in a corporate capacity, measuring, however, the amount of tax by the income of the corporation, with certain qualifications prescribed by the Act itself, citing Flint v. Stone Tracy through to Stratton's Independence v. Howard, 1913. So it's a tax that measures it. And of course, they avoided the difficulty that same year by imposing not a direct tax, but a tariff. The Underwood-Simmons Tariff Act of October 3rd, 1913. A tariff is an impost that's a tax on foreign goods, foreign imports, and on foreign persons working in America. It was also used to tax all activity in the possessions. And it was enacted as a tariff, which is an impost which only taxes foreign activity, and that's why the income tax previous to World War II was only collected, authorized for collection, and required to be collected from foreigners, non-resident aliens under 1441, foreign corporations under Section 1442. And then the collector, the person that withheld money as tax from payments made to foreign persons, the withholding agent, was made liable for the tax he'd collected. Got to pay it all over to the Treasury. You don't get to keep it. There is no collection from American citizens of any tax until you get to the victory tax, which was an unconstitutional direct tax on the labor of the American people during World War II that they got away with and set the precedent for lying to you ever since then about the 16th Amendment. It's all fraud. It's all a constitutional fraud. Every home taken has been done so unconstitutionally. Every car, every job, every life, every prison sentence, it's all constitutional fraud based on a power to tax that the Supreme Court says never existed. Never existed for the courts to enforce. It never existed. It's all been done by courts without subject matter jurisdiction to act. I'm pretty sure that's it.